certain criminal proceedings and the regulation of charitable bail organizations.
Mr. Smithy.
Thank you, Mr. Speaker. And thank you to the members for indulging us as we try to explain this bill. It's a very important bill. I think it's probably the most important bill, not only that I've ever worked on, but also, as far as I know, I've never voted on any legislation more important than what we're getting ready to consider, because it holds the very key to life or death of some very wonderful people, some very innocent people. I wish that every one of you could have been with Senator Huffman and me a week before last, as we were allowed to sit in on a round table with Governor Abbott and a number of the families of victims, mainly of young children who had been brutally murdered. We also had some women there who were rape survivors. We listened to their stories. If you had been there, you would have heard those stories. That's why I wish you could have been there, but just a couple of them. If you had been there, you would have met Scott. Scott was the father of Naomi. Naomi was brutally murdered here in Travis County. The individual, the man who performed the act, had 5 prior felony convictions. He had most recently been arrested on a weapons charge, and he was out on a personal recognizance bond. While out on the personal recognizance bond, he murdered little Naomi. You would have met Jim and Connie, who were parents of Christopher. Back in 2020, he was 26 years old. He was robbed and murdered by a gang of 5. 2 of those murderers were out on bail at the time. And it took them 37 days to find the body of Christopher. One other person that you would have met was Sophia. She, a very impressive young African-American woman who had started a multi-million-dollar business. She's an entrepreneur here in the Austin area. She was attacked by a man she did not know who raped and tortured her for a number of hours. Fortunately, they were able to apprehend the defendant. He was convicted of the crime, but inexplicably, when the individual after he had been found guilty by a jury verdict, he asked the judge if he could be released on bond pending his sentencing, and the judge released him on $750,000 bond, which cost $75,000 bond, which cost $7,500 to be released. Once he was released, he's never been apprehended again. He's remained on the loose, and he happened to steal her identity at the time. He got her identity documents, and he's been tormenting her ever since with identity theft, and has basically destroyed the multi-million-dollar business that she built up. This is what crime has done to some of our families. And what all of these cases and so many more have in common is they are a result of what Governor Abbott has described as a broken bail system. And so Senate Bill 9 is a comprehensive bill that has been developed both in the Senate with the assistance of the governor and with the assistance of many members here in the Texas House. And so I'm going to yield now to some of the members of the House who've been working on this legislation with us together, and let them kind of explain. It's a very detailed bill, and let them explain the various aspects of Senate Bill 9.
Chair recognizes Mr. Louderback.
Thank you, Mr. Speaker, members. My entire career has been fighting crime and criminality. Due to a location on a major thoroughfare, Jackson County was a rural county, but seriously fighting the cartels as a drug trafficking corridor and human trafficking corridor. We encountered a lot of bad hombres. I stand before you today because we truly need significant reforms on our system of bail. Reports show that since 2019, over 200 criminal cases in the greater Houston area involved defendants previously released on low cash or no cash bonds who subsequently assaulted or killed another person. Those victims' lives were changed forever. Some of their lives were ended and their families were left to wonder how on earth the killer was out on our streets. As a sheriff, I had to answer these questions on a regular basis as to how that person got out and was able to commit another crime, another felony. How did they get out of jail? How did they get out? I had to tell them, our bail system. I can speak as a law enforcement officer about the frustration we feel when the hard work of our detectives and investigators to protect the public is diminished or outright jeopardized by our partners in the criminal court system, some of who have inexplicably released violent criminals back into our streets, many times beating the reports that have to be produced. A study in Dallas examining 464 arrests from 2021 found that 56% of individuals charged with violent crimes or weapons law violations were released on bail on their own recognizance. This included about 34% of those arrested for murder. I'll repeat that more plainly. 1 in 3 suspects arrested for murder were out on bail and back on Dallas County streets in no time. The numbers tell the story here. We have a crisis in our state of violent offenders that our law enforcement agencies have worked hard to identify and arrest are going right back into our communities. There's an old saying in the law enforcement world, beat you on the elevator before you get back out, back to the street. It doesn't have to be this way. It seriously does not have to be this way. I ask you to vote for Senate Bill 9 because one aggravated robbery is too much. One assault is too much. One murder is far too much. We can do better. We can do better as a state. And this bill is a great step in restoring trust in law enforcement and our criminal justice system.
Chair recognizes Mr. Little.
Thank you, Mr. Speaker. Members, I'm going to take a few minutes to explain some of the more technical components of this bill. You may or may not be aware that there is an overlap between the work that magistrates do and the work that judicial district court judges do. One of the components of the bill is we're going to prohibit certain magistrates from reducing bonds set by district courts, so there is not a conflict between decisions reached by district courts and magistrates in ways that harm public safety. Another component of this bill is to require magistrates to consider the public safety report and to ensure the appearance of the defendant before making any type of decision to release that defendant on a felony offense. One of the most important components of this bill, I believe, that you need to consider is the appellate remedy. From time to time, we're going to see magistrates or district judges make mistakes or make bad decisions about bail concerning violent offenses. And Senate Bill 9 is going to equip the prosecutor and the state prosecuting attorney with the ability to appeal those decisions and leave that defendant in jail for a period of 20 days while that decision goes up on an appeal to determine whether public safety is served by continuing to confine that defendant. And it's going to require the judge to document and make certain findings to support that decision of holding the defendant on bond or even releasing the defendant on bond. Giving the state the ability to appeal insufficient bail orders for specified violent felony offenses is going to be important. It's going to make the people in our districts back home safer, and it's going to protect us from ongoing violent conduct by people who are repeat violent offenders. Thank you, and I encourage you to vote in support of Senate Bill 9.
Chair recognizes Speaker Moody.
Thank you, Mr. Speaker and members. I'm going to walk through real quick sections 17, 18, 19, and 20 of SB 9. As we heard this bill in committee, the father of a young victim, murder victim, talked about how he was unable to get particular information about whether certain individuals were, or the individual in his case, was complying with his bail conditions. It was a question I think kind of stumped a lot of us, thinking, well, we have a lot of victim-centric information flow in our criminal justice system to make sure that they're informed, they know when hearings are, they know what's going on, the DA's office are supposed to keep in touch with them. And we looked through the statute that night and we realized that there was a glaring loophole, that this is information that was not provided to victims. So you'll see on page 18, that information is now going to be provided as part of the victim's rights. They get to know whether these people are complying with their bail conditions. And that's an important response to some of the concerns that we heard in committee. In the following section, we're going to require that the Office of Court Administration bail form is going to be used in certain list of offenses. You'll find that on page 20 of your bill. I apologize, 21 of your bill. And then another victim-centric portion is in section 19 relating to notice to submit information to magistrates for bail consideration. These are when we're talking about victims of family violence, stalking, harassment, and terroristic threat. So that's more information. And then we have a repealer in section 20, and that repeals a previous iteration of when a bail report deadline was due, which is now moot by the rest of these other terms in the bill, so it's being repealed. That brings us to just the enacting portion of the bill. So now you've been walked through the different provisions. This is a large piece of legislation. Again, I think we've gathered a lot of input. There are pieces to this that I certainly, I think, could create issues with efficiency in our courts. But I think we've struck a balance here to make sure that there is accountability when these decisions are being made, that there are structures in place, and that we're going to make sure that we have answers for those victims of crime. And that's the component that I wanted to discuss with you here at the end. I certainly intend to vote yes on this. I look forward to the conversation about the bill. Thank you.
Chair recognizes Mr. Smithy.
So I hope you have a better understanding of the bill. It does a lot of things, but everything in this bill has been carefully thought out. We've worked hard to work with both the Senate and the governor to ensure that we get this finally done. We've tried, Mr. Moody reminded me, we've tried this for 5 sessions. This is the 5th session we've worked on this. And in those 5 sessions that have transpired, we've had a number of senseless murders and other crimes committed that would have been prevented if this legislation had passed. And so I would just ask for your prayerful consideration as you consider this. And I'll be glad to address any questions.
Mr. Cook, for what purpose?
Will the gentleman answer a few questions?
Gentleman yield for questions.
Certainly.
He yields for questions.
Thank you, Mr. Speaker. Mr. Chairman, under the bill, there's a definition for clear and convincing evidence. Is that correct?
That's correct.
And can you tell the body just what your understanding is of the definition with regard to clear and convincing evidence is it's in it? I mean,
Well, it's defined at least twice in statute, once in Chapter 41 of the Civil Practices and Remedies Code, and another, and also in the Family Code. But there is also, we have one instance of clear and convincing evidence in this statute, and that is what well, actually, it's in the constitutional amendment that accompanies one of the constitutional amendments that there must be, the prosecution must prove by clear and convincing evidence that either the defendant is a flight risk or else is a security risk to society. And that would have to be, right now as worded, it would have to be done by clear and convincing evidence. Clear and convincing is somewhere between preponderance of the evidence and beyond a reasonable doubt. And basically, clear and convincing would mean that the courts have defined it as meaning sufficient evidence that would yield a firm belief in conviction in the truth of the matter asserted.
that's how the courts have interpreted it. Is that correct?
That's correct. It's well developed in case law, in common law, and so I think the feeling of everyone is we don't need to define it again in this statute.
So my understanding, there's an amendment to remove clear and convincing from the.
There
this
will be
bill.
an amendment to remove that language.
Okay, great, thank you for that. The reasoning behind the amendment is that putting it in statute, we might inadvertently limit or shift how courts interpret the term in other legal contexts or risk conflicting with future appellate rulings. Is that a fair summary of why
Yeah.
we're removing it?
I think that's absolutely correct. We're trying to avoid any confusion in the event of any appellate proceedings.
And Chairman, under your bill, a magistrate in a county with over 200,000 residents would be prohibited from granting bail to defendants who are already out on bond, parole, or community supervision for a felony that they commit when they commit a new felony. Is that correct?
Well, the way it works is that in those counties that are over 200,000, the magistrate will not be a magistrate will not be able to release a defendant. A judge could still release a defendant on bail, is my understanding, based on that language. The judge, a regular district judge, could execute that release, but not a magistrate.
And in addition to that, if someone has already been previously convicted on 2 prior felony convictions and served prison, they would be ineligible for release by a magistrate under this bill. Is that correct?
Yes, and what this responds to, Mr. Cook, is there are some individuals who really have no business being released back onto the streets. And we're just trying to put in an extra safety measure here to make sure that we capture the right individuals, that the individuals who should not be on the streets are not just simply allowed back on the streets.
And you've also included safeguards for those that are subject to an immigration detainer issued by ICE. That's part of this bill as well. Is that correct?
Yeah, it recognizes the reality that if you are in the country illegally, in fact, if you meet the definition of an alien in federal statute, if you commit one of these more serious crimes, there's going to be an ICE detainer on you. And what that means is that when the state's finished with you, you're not finished, because then you go into the custody of ICE.
And then with regard to certain crimes, I believe that there's provisions in this bill that also bars the release of the defendant if they're charged with certain violent crimes, such as murder, capital murder, aggravated kidnapping, or aggravated sexual assault. I mean, we're taking a hard stop on those crimes. Is that correct?
Yeah, and it's what are traditionally referred to as 3G offenses. They are the offenses that are particularly dangerous: murder, aggravated offenses like aggravated rape or aggravated assault, which are typically referred to as 3G offenses, and those offenses are fairly well defined.
Okay. And with regard to those crimes, those bail decisions will be made by district judges that are accountable to the voters, not by magistrates. Is that correct?
Right, and there may be some instances where bail would be appropriate in those instances, but we want to make sure we have a district judge making those decisions.
Someone with electoral responsibility or accountability.
Electoral responsibility, and also more training in the law.
Great. And there's also a new notification process, is that correct, where someone who commits a new felony while on bond for another felony, it triggers notice when the defendant is brought before a magistrate, not just simply that they're charged, but that notice is invoked. That's different from current law, is that correct?
Yes, what we want to make sure of is if an individual is out on bail in one court and they commit a felony in another jurisdiction, that the first court is made aware of that second offense, so that the court can consider whether or not to revoke bail. It's basically a better transparency mechanism to make sure that if a defendant is in more than one court or is in more than one proceeding, that we have transparency between those proceedings, so we get a full picture of the risk that defendant poses to society.
And that notice is going to go to a designated individual for each county, is that correct?
Yes, the county designates an individual who is responsible then for communicating that to the applicable court.
And it must take place prior to the next business day?
That's right.
Finally, when a new felony is committed while someone is out on bail for a prior felony, the court handling the earlier case must reevaluate the original bond under this new bill as well. Is that correct?
That's correct.
That's a new statutory requirement?
Yes.
Okay. And Chairman, let me make sure that I understand the structure that you've put in place here. Under this bill, if a magistrate sets bail on a felony case, but the magistrate serves a court that doesn't have jurisdiction to try that offense, a district judge can now step in and review that decision. Is that correct?
That's correct.
Okay. And it doesn't matter if the defendant has already been indicted or if the case is still in the pre-filing stage, so long as the charge will land in that county and a district judge is there that can review the magistrate's bail decision. Is that right?
That's correct.
Okay. And your bill also requires that the local administrative judge in each county to establish a process for their jurisdiction, their county. Is that correct?
That's right.
Okay. And that process is for the district clerk to notify all district judges when a request for bail review comes in from the state's attorney. Did I read that correctly in the bill?
That's correct as well.
Okay. Next, and once the district clerk receives that request, the district judge has to review the original bail order no later than the next business day, right?
Right.
Okay. And if the judge decides to increase the bail or add additional conditions for someone who isn't currently in custody, they can't just issue a warrant. They have to issue a summons and give that defendant a reasonable time to show up first, just from a due process protection. Is that correct?
That's accurate.
Okay. And during the review, the district judge is required to consider all applicable factors such as bail duration, prior proceedings, new conditions, and weigh the facts and the rules properly before making a change. Is that right?
Correct.
All right. And this provision just adds a level of oversight that I think that the public has been requesting, especially when bail decisions are being made at the lower levels. And I just want to say I appreciate you providing that safeguard, and I too will be voting in favor of Senate Bill 9. I think it's a great bill, and I just want to say thank you, Mr. Chairman, for all of your work. I know you spent a great deal of time with regard to Senate Bill 9, and I just want to say thank you.
Well, thank you for your help on the bill. You've had a tremendous input and influence on the bill, and we appreciate that.
Thank you, Chairman.
Thank you.
Mr. Wally, for what purpose?
Thank you, Mr. Speaker. Would Chairman Smith yield just for...
Yes, sir.
Gentleman yield for questions. He yields for questions.
Thank you, Mr. Speaker. Thank you, Chairman Smithy, for your work on this bill. I just wanted to flesh out, I know Representative Cook asked some specific questions, and I want to flesh this out a little bit more so that, as you know, it is true that denying somebody bail, their life and liberty, it's a very serious matter. Is that correct?
It is a very serious matter.
And we have to have some constitutional safeguards, statutory safeguards, so that we're not unjustly holding somebody or detaining somebody, taking their liberty away. And we have to have some safeguards for that. Is that correct?
It's all about a balancing, as you know, Mr. Wally. We want to keep the right people in jail and get the other people out of jail, if possible.
And to
so-
that point, the right people out of jail, the bad people in jail, I get that. I just wanted to flesh out some of the specific enumerated crimes that SB9 prohibits release for. And so right now, SB9 prohibits release on personal bond, release without financial requirements, for defendants charged with the following offenses, even if it is their first offense. I want to start there. Even if it's their first offense, SB9 prohibits the release on personal bond for somebody that's murder arising from the manufacture or delivery of penalty group 1B substances. Is that correct?
That's correct.
Okay. Also, somebody who's been alleged to have committed a terroristic threats chargeable as Class A misdemeanor or higher. Is that correct?
Yes, yes.
Okay. Violations of certain court orders or conditions of bond. Is that correct?
That's right.
Okay. And unlawful possession of a firearm by a felon. Is that correct?
That's correct.
Okay. It also prohibits bond for individuals on parole if they commit a felony.
Well, actually, let me correct you. It doesn't prohibit bail for those individuals, but by a personal recognizance bond. So you're going to have to post a monetary bail or bond. And it could be in really any amount set by the court. But right now, a lot of times the defendant is released on personal recognizance. And so we're trying to tighten that up a little bit for some of these more serious crimes.
Okay. So for somebody, particular financial bail, I guess, for somebody that commits a felony, assault, deadly conduct, or disorderly conduct involving the discharge of a firearm in public or the display of a firearm or other deadly weapon in public to alarm people. Is that my understanding as well?
I think so. I think that's the way it's worded.
Okay. I just want to make those clarifications so
Okay.
that the public's aware of what we're doing this morning.
And I think what we're trying to do is stop this revolving door where,
I get that.
yeah. Okay. So
Yeah, no,
it's-
I get that. You particularly for folks that are, but this first class, these are for folks that have committed their first offense.
Yeah.
That's my understanding. Okay.
Yes.
And then this applies, as mentioned, to populations over 200,000. Is that my understanding?
Well,
for
that's
counties?
a different provision of the
Okay.
bill. That just says that in a county over 200,000, a magistrate cannot make a decision to release a defendant of committing serious crimes. It has to be a district judge that
Okay.
makes that decision.
So let me clarify that. So in counties with populations over 200,000, magistrates appointed under Chapter 54 of the Government Code may not release a defendant on bail if the defendant was, one, on bail, parole, or community supervision for a felony and is charged with a new felony. Is that correct?
That's correct.
Okay. Has two or more felony convictions resulting in TDCJ imprisonment. Is that correct?
Correct.
Okay. Is subject to an ICE detainer.
Yes.
Okay. Or is charged with murder, capital murder, aggravated kidnapping, or aggravated sexual assault. That applies to counties with populations over 200,000. Is that my understanding?
That's right.
Okay.
Now,
And-
if you're under 200,000, a magistrate can make that decision.
Okay. On that note, why would we limit, why would not this provision apply statewide?
Well, that's a good question. You know, it came that way from the Senate, and there did not appear to be any good reason to change it. I would say there's two reasons. One is that most of the problems that we're seeing today with bail are not all, most of the problems are occurring in counties over 200,000.
But that doesn't mean that it doesn't happen in counties less than 200,000.
No, I've got an instance, you know, where it's happened. I mean, I can't reveal. I mean, I can't really cite the name, but I know it's happened in a county of less than 200,000. It's much more rare. And the other issue is the available resources that are available. Like a number of rural counties in the state have no individual district judge. It's basically a circuit judge that covers
travels
several
around,
counties.
travels
Yes.
multiple counties. I
And
understand.
so that seemed like a logical place to break off the population was at 200,000.
I think that is a concern of mine, particularly if we're concerned about public safety. We should be concerned about rural communities that might have this issue as well. Now, you mentioned that this seems to be more prevalent. There's a lot of media coverage, and rightfully so, in very egregious evildoers that do this repeated offense. We want to hold those folks accountable. I get that. I guess my concern would be if it applies, you know, for my county and Harris County, it should apply for a rural community as well if that's happening in a rural community. Because I'm concerned about the victims of crimes in Harris County just as equally I would in a rural community, in your community, in the Panhandle or in West Texas. That's my only concern with this provision of the bill, is it applying statewide. And we'll come back to that point.
Okay.
Let me also flesh out. I know Representative Little talked about the appeals portion of the pretrial detention. So SB9 allows prosecutors to appeal bail amounts they consider insufficient for certain serious offenses or felony offenses committed while on bail for another felony offense. Is that my understanding of the bill?
Right.
Okay. Defendants who are already in custody must remain incarcerated during the appeal. Is that my understanding?
That's correct, up to
Okay.
20 days.
Up to 20 days. And I was going to get to that. The Texas Supreme Court must adopt rules for expedited appeal procedures for bail in which rulings must be issued within those 20 days. Is that my understanding?
Right.
Okay. And then, so a district judge, either in the county where the defendant is being tried or where the felony charge will be filed, may modify a bail decision made by a magistrate of a court without jurisdiction over the offense, regardless of whether the formal charges have been filed. Is that my understanding of the bill as well?
I think that's the language in the bill, yes.
Okay. The local administrative judge must create a procedure for district clerks to notify district judges when a request to review a bail decision is received, and district judges must act by the next business day. Is that my understanding?
Well, there's two provisions.
Okay.
One is basically an appeal from a magistrate's decision to a district judge.
Okay.
And that's in one section. The other section is really a bail decision that's made that the prosecutor feels is an adequate or insufficient amount of bail, will have an expedited appeal to the Court of Appeals.
Okay. And if the judge decides to modify a bail decision, the judge must issue a summons for the defendant to appear and give the defendant a reasonable opportunity to appear before issuing a warrant, an arrest warrant. Is that?
Yeah, and that would mean that if a magistrate had set bail at $1,000, it was posted, and then that was appealed to the district judge. The district judge said, no, that's not enough. You need $10,000 of bail in this case. Then the defendant would be given reasonable notice and an opportunity to post the additional amount of bail before they would be brought into custody.
And so there's some other key provisions that SB9 includes, and that would be, and I think this has been mentioned several times, the standard of proof codifies that SB9 again codifies clear and convincing evidence as the standard required to establish a firm belief or conviction in the truth of allegations used to justify detention or bail conditions. Is that being codified?
Mr. Wally, that's correct, except there is an amendment coming.
Okay.
I discussed this, I think, with Mr. Cook a moment ago on the exchange, to take the clear and convincing definition out of the bill.
Okay. Why would we do that?
Well, the consensus was that the clear and convincing standard is well developed in common law, in case law. It's used primarily in family law cases. And we felt like the consensus among those that were working on it was that we might create confusion if we further defined it in this particular statute.
What standard of proof would we be using?
Well, we would use the clear and convincing standard.
Okay.
And there's nothing...
In practice, but not codified?
Well, no. It's in Senate, clear and convincing is in SJR 5.
Okay.
It's another... And so what this was doing, instead of defining it, the standard in the Constitution, we were just defining it in statute. But as I say, the consensus was better that it's developed in common law. There was no need to further define it.
I understand that. And just again, to keep fleshing this out, if a defendant previously released on bail for a felony is charged with a new felony, SB9 requires an electronic notice to be sent by the next business day to a designated individual in the county so that the court may consider revoking, modifying, or reevaluating the previous bail decision.
Yes.
I think that was touched upon by Representative Cook, is it my
I
understanding?
think we discussed that.
Okay. SB9 mandates that bail organizations submit monthly reports to the Office of Court Administration detailing specific charge and bond information, including whether any bond forfeitures occurred. Is that my understanding?
Yeah, now this is the section that deals with these nonprofit organizations that take nonprofit money and provide funding for bonds for defendants.
Okay, and then I think we've mentioned on the record that doesn't happen.
Well,
There's dispute that it happens or not happens.
Well, there's no dispute that we do have these nonprofit organizations out there that do this. The dispute was over whether any taxpayer funds are going to these organizations, and so...
Okay, and that's a good clarification.
Yeah,
So we're just codifying what is already prohibited under current law. Is that my understanding?
Well, that was the last bill.
The last bill, okay.
Yeah, the last bill. Now,
Okay.
this bill is just kind of beefing up the reporting requirements. These groups are already required to report to the Office of Court Administration And so this is just kind of giving a little more detailed information to OCA so they can evaluate whether the law is being followed.
And then to that point, the bill, as you mentioned, requires the OCA to report any suspected violations of this requirement to the county sheriff.
That's correct.
Okay. And then there's a section on victim notifications on bail compliance.
Yes.
And so SB9 gives victims, guardians of victims, or close relatives of deceased victims the right to be informed of whether a defendant has complied with bail. Is that my understanding as well?
That's right. It's a victim's rights provision that allows, if a defendant has violated bail, I think everyone agrees that the victim should have a right to know, because it could affect the victim's safety. It could affect how, if the victim is still living, or the family of the deceased victim, it would be something they would want to know.
I think that's a good thing.
Yep.
Victims do need to be notified, so I have no issues with there. But again, just trying to flesh this out. SB9 also expands the responsibilities of Texas courts and the OCA through new reporting requirements. Is that my understanding?
There's some new reporting requirements. I don't think they're onerous by any means.
No,
Yep.
not suggestion, but I just want to flesh that
Yep.
out too. Under SB9, the public safety report system must now include additional data points and support broader access to prosecutors and district attorneys. Is that what this reporting requirement does?
Yes, we're trying to get full transparency in the criminal justice system so that everyone who's making these decisions has all the information they need to make a good decision.
Okay, and then additionally, SB9 requires the public safety reporting system to be configured to integrate county or municipal jail records and case management systems. That's logistically, that's important as well, because you have, obviously you have the Office of Court Administration, but I'm not sure what Harris County does different than Fort
Yep.
Bend or whatever.
Well, one of the problems is that the various counties have different software in place,
Correct.
and it's very difficult to get this information out there. But we have 254 counties, and we want to make sure that whatever county you're in, you get all the information that you need in order to make an informed decision if you're making any kind of bail decision.
Okay. To that point, the bill allows the Office of Court Administration to provide reimbursement grants to local governments for integration costs, but only if funds are appropriated by the legislature. Is that my understanding?
Exactly.
Okay.
And the counties are going to have to do some software updates to get this system fully implemented, and we would anticipate, I don't know if it's in the current budget, you would have more idea on that than I would, but I would anticipate at some point that we will help the counties out on that so that it doesn't become an unfunded mandate.
To that point, do you anticipate in negotiations, look, I serve on the Appropriations Committee, but do you have any knowledge about any reimbursements that some of the counties would have to incur globally? One for integration and the software integration, that's one, but also new staff, additional prosecutors, additional jailers, additional space in our jails. Did we flush that out in the bill as well?
Yeah, I think that it's probably too early to know what the cost is going to be. I think it would probably be better to retroactively reimburse that at some point. We still don't have a good handle on that. As far as additional costs that these reforms will impose on counties, I would say this, that we were very careful in this bill. Sheriff Louderback deserves, I think, a lot of credit because he's managed a jail, he's run a jail, and he knows where to go to get the information. So we actually went to the detail of looking at each county in the state, their jail capacity, their available jail capacity. We looked at the number of cases that have been generated in the past in each of these classifications of felonies to see what population impact we might have. We basically designed the bill and the whole package to fit the capacity that we've got. And we're trying to be mindful of that. We don't want to have to go out and build new jails or make counties build new jails. But there may be additional cost on some of these to counties because there'll be.
The gentleman's time has expired.
Yeah, just what? I think I'm in
Mr.
order
Waller, for what purpose?
one extension of time.
Members, you've heard the motion. Is there objection? Chair is none so ordered.
Thank you, Mr. Speaker. Just to flush this out on the costs to local counties and the jails. And look, we run the largest jail system in the state at Harris County, and also commingles as the largest mental institution in the state. We prescribe millions of dollars probably of prescription drugs that some of these folks need. They need that medication. Was there any discussion with any of the counties on implementation of this? This is a monumental bill. And look, I'm going to support the bill. Let me just say that. But I do want to flush these things out so that Texans are aware of what we're about to do in a few minutes. Were any of the counties consulted?
Well, I know we
on
did
these
have
changes?
testimony, I think, in the committee or shortly after that. We have had a number of counties contact us with suggestions as to how we could reduce the cost, and we've tried to follow those. I would say this, that most of the offenses and most of the defendants that are covered in this legislation are already going to be held in custody in jails. This is basically trying to ensure that those that slip between the cracks and are released because of a bad decision or whatever, that we are able to keep those defendants incarcerated. So I don't think this is going to be a big increase in the number of inmates that we're housing in Texas, because most of these that fit into these categories are already there. We're just aiming for a few that are slipping through the cracks, and those unfortunately are the ones that can do a lot of damage to people. It can ruin people's lives, kill people, and ruin their lives.
No, I certainly agree with that sentiment. No argument on that point.
And I think very to address your problem, I think, and I've talked to Senator Huffman about this, and I think very possibly when we come back next time, and we're going to have to look at helping some of the counties out on this, because we'll have a lot better data at that point to know if there is, how much additional cost there is. And there's no more function of government, in my opinion, more important than protecting our innocent citizens. I think we have to do that. And so we basically spend what we have to spend to protect our people. And so
I agree with that sentiment. We need to hold people accountable for the crimes they commit. But I also know that we do have a constitution. Folks do have a constitutional, it's the bedrock of our criminal judicial system. And we have to strike that balance. And so I understand the need to strike the balance in these bills in enumerating certain crimes like murder, terroristic threat, violations of certain conditions on bond, possession of firearms. I don't think you'll get any argument for many people, at least for me, I'm sorry, that folks that are repeat offenders should be held accountable and should have a shorter leash, I guess, if you want to call it, than being let out on bond while they're awaiting trial on other crimes. And so when they commit subsequent crimes, it's a problem. So I get that. Just again, I wanted to come back to the county threshold, the 200,000 and the magistrate issue. Is there any sentiment either on the Senate side, or at least from you that's carrying the bill on this side, that we could apply this bill statewide? Because I'm almost positive, I don't have any proof, but I'm almost positive that this would be an issue in other parts of the state as well, not just in Harris County.
Well, it's not an issue to the extent that it is in the larger counties. It's not just Harris County. I think Travis County's been a problem, Dallas County to some extent. And so that's where the problem has been. That's where what we were trying to address. I would say this, Mr. Woolley, I think that it is probably a good place to start at 200,000, and then next session, if we can reevaluate and see if that number needs to be raised or lowered or eliminated altogether. But it just seemed, like I say, it came from the Senate that way. We're trying to, avoid a conference committee on this so that we can finally get this done. And it seemed like there was a logical reason to keep it at 200,000 for
I
two
think
reasons.
you mentioned earlier that you're going to include an amendment that takes out clear and convincing. Well, you're already going to go to conference, I assume,
No,
by making changes. Or am I wrong in my
yes.
assessment on that? If you're going to make change, you're already going to accept the amendment. You're going to change the bill, so you'd have to go to conference. I
No,
don't know. You tell me if I don't know my rule book correctly.
Well, we've been working with Senator Huffman
Okay.
and the Senate on this, and I think that I'm going to have an amendment that will have some cleanup language, including in a moment, including removal of clear and convincing. That amendment has been cleared with the Senate
Okay.
and with the governor's office, so it would. We're hoping that the Senate will simply concur in the bill
Okay.
if we're fortunate enough to pass here.
Okay, well, I appreciate your time and appreciate your work on it, and the folks that have worked on it, I know, have tried to put some constraints on this so that we're not, we're not in prison, we're not incarcerating folks
Yeah.
or detaining folks without due process. So I appreciate your time.
Well, I appreciate you reading the bill in so much detail. Thanks.
Ms. Jones, for what purpose?
Will the gentleman yield for questions?
Gentleman yield for questions?
Certainly.
He yields for questions.
Good morning, Chair Smithy. Just want to clarify some things related to charitable bail. Is it true that under SB9, charitable bail organizations are only prohibited from posting personal bonds, not monetary bonds? Is that accurate?
They're not prohibited from posting monetary bonds.
Okay.
Yeah.
And can charitable bail organizations still post a cash bond for a person charged with a violent felony like aggravated assault?
Yes, if they can under current law, I think they will still be able to do that. I think all we're trying to do with charitable organizations in this bill is just increase the reporting requirements.
And under what circumstances can a charitable bail organization lose its ability to post a bail?
Well, so I think that's a decision that'll be made locally. And so basically what OCA, or Office of Court Administration, does is collect the information and compile the information, and then they report it to the local authorities. If a charitable bail organization is violating the law on a repeated pattern, they could probably be prohibited from doing that in the future.
And is the law merely reporting? You say if they're violating the law repeatedly, like what is that law that they have to report?
Well, there are a
and they're
number
not
of,
reporting?
is my understanding, and is that there are a number of requirements imposed on charitable bond organizations as to how they operate. And so, I think we're not trying to eliminate those organizations at all. Nobody really wants to do that. I think what we're saying is, well, first of all, they don't get any taxpayer money. And secondly, they need to be transparent through Office of Court Administration with their operations.
Right.
There's a real problem in those areas because in any nonprofit or charitable organization, you have a potential for fraud where money is being contributed and it's not being used the way it was intended. And I think there are a number of concerns that we're trying to address to make sure that there's full transparency with those organizations that are purporting to do bond.
So now are charitable bail organizations they're going to be audited or something by somebody? And if so, who?
No,
So if you don't like what bails that they're making, then
No.
you can go in and try to
No.
find a reason to stop them from being able to post bonds?
Mr. Little just pointed out, and it's true, in current law, we can already, the mechanism is already there to suspend one of these organizations from operating in the state if they violate the rules that apply to them. And so what this bill, really all this does with charitable bond organizations is just beef up the reporting requirements and It doesn't eliminate them, doesn't stop them from doing what they do. It just beefs that up.
So the charitable bail organizations have to report every bond they post each month?
Well, I can't remember exactly what they have to report, but there's a prescribed report that they have to file with Office of Court Administration, and
Then does this sound right?
well,
They must submit a
well,
monthly.
you're correct.
They have to support a monthly report to OCA by the 10th of each month,
Yep.
listing each defendant, charge, cause number, bond amount, jurisdiction, and any failures to appear on bond or forfeiture. So that now means that the charitable bail organizations must track the people that they post bonds for? Is that what you're saying?
Well, they already do that. They already have to track the name of the defendant, the cause number of the case, and now we're adding that they have to put in there each charge for which the bond was paid, so we'll have an idea of what the bonds are being posted for, and the category of offense for each charge, and the amount of the
The
bond
gentleman's
paid.
time has expired.
Thank you.
Thank you.